Good afternoon, everyone. Just barely afternoon. We appreciate the participation we get in these webinars. I'm sure wherever you are today, it's a nice, hot, and probably muggy day. So sit back with your iced tea or lemonade or something stronger if you're so inclined. And let's talk about the U.S. Constitution and your association. Constitutional law is one of those classes you take in law school that's mandatory, and like criminal law, you sit there and think, I'm never going to use this. This isn't really important to me unless you practice in this area. And you soon learn that's not true. The Constitution is the basic source of all of our laws, and it governs and constrains all of our laws. It applies to the federal government. It applies to individual rights. It applies to states through the 14th Amendment to the Constitution. The Constitution generally does not apply to private entities. If I tell my kids to shut up, they don't have a right of free speech. Because I'm not the government. So the first question we ask is, so that being the case, why is this important in condominium associations? We're not the government. How does it apply? So we're going to start by a brief explanation of that concept, which in legalese is called state action. I'm Joe Adams. I am a shareholder with the Becker firm. I practice in the firm's Naples and Fort Myers offices. I'm board certified by the Florida Bar in condominium and plan development law, and I've been with the firm for about 35 years. I started in junior high school. So I'm going to introduce my partner, Jroberts. Jay is going to do the heavy lifting and answer my questions. But Jay, why don't you start by introducing yourself?
Yeah, hey everybody, I'm Jroberts. I am a shareholder in the community association practice. I'm also board certified in the same area of law Joe is. I'm up in Fort Walton Beach, Florida, Panhandle, LA, Lower Alabama, the Emerald Coast, whatever you want to call it. I'm up in that area of Florida. And glad to be with you today, and hopefully we have some interesting topics to go through.
So Jay, let's start with the basics. Condo associations and HOAs are not governmental entities. So does the Constitution apply, or does it apply in some circumstances, and why?
Yeah, so two separate issues. And I want to mention the first one because we're not going to spend as much time on it. The Florida Supreme Court has announced in several different cases that there are limits on the restrictions that can be in covenants and declaration of condominiums. We've talked about this in other classes. There's really two tiers of restrictions. There's tier one restrictions, which are those that are contained in the recorded governing documents. There's tier two restrictions, and those are board rules and those kind of things. And you got broader ability to restrict in the recorded documents, but it's not unfettered. What the Supreme Court of Florida has said is that those restrictions in the governing documents cannot be wholly arbitrary, cannot violate public policy, and cannot abrogate some fundamental constitutional right. So while we're going to talk about how the actual Constitution can play into enforcement issues in the community association setting, here's an independent way where a court could say, look, we don't even have to get to the constitutional question of whether you are a state actor, which we'll talk a lot more about. The courts could just say, look, we think that this restriction violates something in public policy that's laid down by the state of Florida, or we think that it abrogates a fundamental constitutional right, and we don't have to worry about whether you're a state actor or not. So that's one issue. The other issue is a state actor. I mean, like Joe said, initially and originally, the Constitution only applied to the federal government. Then came along the Civil Rights Amendments, the 13th, 14th, and 15th, and the 14th Amendment made the U.S. Constitution and all of the Bill of Rights and everything else apply to state and local government. So how do we get from that point to where we are today with state actors? Well, it really comes into play with one important case in 1948 called Shelley versus Kramer. In Shelley versus Kramer, what you had was a restricted covenant that said nobody of African-American descent and nobody of Asian descent can live in this townhouse community. Brownstones is what they called them there. And, we had Mr. Shelley, the Shelley family is African-American, bought a lot there, and Mr. Kramer, his neighbor, sued and said in court that, look, we have this private restriction. Mr. Shelley's violating it. He can't do that. He can't live here. And it went up through the court systems and it went to the United States Supreme Court. What the United States Supreme Court said is like, look, the private restriction in and of itself is not a problem, or at least from a constitutional perspective. It may be abhorrent, but it is not constitutionally a problem. But the minute you walked into the court with the power of the state behind the court to enforce your private agreement, you, my friend, have become a state actor, and you are bound by the U.S. Constitution. And in this case, the Equal Protection Clause, the Fifth Amendment, as applied to the 14th.
Okay, so basically what Shelley versus Kramer said, and this is a 1948 case, is that if you use the court to enforce an unconstitutional restriction, that's state action, right?
Yeah, that's right.
So that makes sense, and I think we would all agree with that outcome. But as we're going to talk about, the courts have not really consistently followed that rule, because obviously Shelley was a racial covenant case. Those are particularly disagreeable, onerous, improper, but we get into things that maybe aren't, like commercial speech, like signs in yards, and the courts have not been quite so consistent on that. So, at the risk of putting everybody to sleep, let's kind of close out the legalese part with a brief discussion of the much more recent Quail Creek case, which arose out of Naples, involved a for sale sign in a front yard, and the Lauren versus Sasser case. They were both association sign cases, both involved constitutional free speech defenses. So tell us about them.
Right. So as Joe said, the Quail Creek case is a state case. The Lauren versus Sasser case was actually a federal case. Someone brought a case saying that the association violated 1983 actions, basically when you sue the government for doing something bad. And in both of those cases, it's interesting, the association was not the plaintiff, did not bring the case. It was the person that wanted the sign, the for sale sign. That's the person who walked into the court and said, declare these restrictions as unconstitutional. And in both of those cases, they said, look, the recorded agreement does not rise to state action. It is you coming into the court to enforce that brings you into state actor land. And in both of those cases, the plaintiffs lost, and the court said, the restriction in and of itself is fine.
So does it make a difference whether the association brings a lawsuit to enforce a covenant or restriction, or is defending a claim by an owner as to whether constitutional arguments will hold water?
Yeah, and this practitioner's opinion, it does. It matters who's going into court. Now, there have been commentators, and there's actually discussion of this in the Lauren case, that Shelley versus Kramer should be confined to the equal protection clause of the Constitution, the racial covenant side, and it hasn't been expanded since. I think that if you read all these cases together, and by the way, you get wildly inconsistent outcomes, you will see that there is a common thread that the court is looking at who is the one trying to either enforce something or get something declared unenforceable.
So it's probably fair to say this is a bit of a legal no man's land. Would you agree with that?
Yeah, I would definitely agree with that.
Okay, so let's move on to kind of the nitty gritty. I was going to call this God, Guns, and Graffiti, but I got overruled. But let's talk about the typical constitutional provisions that would be applicable in the day-to-day issues that associations address. And in my mind, there's probably 4 or 5: freedom of speech and expression, freedom of assembly, Second Amendment right to bear arms, and freedom of religion, and freedom of speech as part of expression and assembly. So let's start with freedom of assembly. If I want to, form a group to, march around the lobby of the condo building and, say, the board is a bunch of nincompoops, do I have the right to do that? What do the statutes say on this, Jay?
Yeah, so interestingly, this is one of those instances where the legislature said, we don't want to leave this up to you guys having to go through the First Amendment of the US Constitution to give yourselves the right to assemble. And both the Condominium Act and the HOA Act, 718.123 and 720.304 respectively, contain the right for the freedom to peaceably assemble. And there's been cases that discuss this, and it's going to tie into the religion aspect, but they say traditionally in US law and common law, the freedom to assemble has been for political purposes. And I think you have some background as to the legislature of why these things were really passed, but that's basically what the laws provide.
Okay. Yeah, and sometimes it's more interesting to learn how a bill really becomes a law, because this one started back in South Florida when a condo president wouldn't let a candidate he didn't like come and speak because he was supporting the other candidate who did get to come and speak. And lo and behold, the one he didn't like got elected and changed the law. So, owners by statute have an absolute right to invite political candidates to speak on the common areas. To the extent the right of assembly in the statute, goes further, like, marching around with the board stinks signs, that's not really, settled by any case law.
Right. So
let's talk about freedom of religion. I am a devout, let's say, Presbyterian, and I'm an ordained minister, and I want to start offering Presbyterian worship services in the association clubhouse every Sunday, just for residents. And the board says, we don't think that's really a good idea. We're not going to allow that. Can I sue for constitutional violation?
Yeah, so this has been brought up in a couple cases, one in a condo and one in an HOA. And in both situations, what the restriction was no religious services, right? None at all. Like, we don't think this is a good idea. We're not going to allow it. And the court The court in both of those cases agreed and said that's a reasonable restriction to have no religious services on the common areas. So I have not seen a case that would allow you, as the Presbyterian minister that is a unit owner, to prevail on constitutional issues if all services are banned. You know, the practical takeaway from this is, you know, something that the U.S. Constitution does speak about in other instances, and that's content regulation. If you're going as a board to say we're not having religious services, that's one thing. If you're going to, as a board, say we're going to allow Presbyterian services but not Jewish services or Islamic services, you're then regulating the content, not the activity, and I think you could get yourself into some trouble there.
Well, what if we allowed Jewish, Muslim, Catholic, and all Protestant services, but banned devil worship services?
I think you still got a problem. I mean, the First Amendment is not going to draw a line in between those different belief systems.
Right. In fact, if you read the First Amendment case law, it's pretty clear that it is intended to protect that which makes most of us uncomfortable.
Right.
Like the devil worship service, right?
Sure.
So let's talk about flags. You know, a lot of people have fought and died for them. The Supreme Court has said that you have the absolute right to burn them. Why is there so much kerfuffle about flying them in condos and HOAs? Let's talk about the 1989 Gerber case and then kind of how the legislature responded to the dispute in that case by changing both 718 and 720 on flags.
Right. So the Gerber case originated out of Tampa. It was a federal trial court case. It never got up past the trial court. And in that case, the dispute was whether Mr. Gerber could fly a U.S. flag from his balcony unit area. And the association didn't allow any flags, and there was nothing in the law about it. So they said, yes, we can prohibit that. And the trial court decision there is pretty long and somewhat interesting. But they found that no, that the association was a state actor in this situation, and that this infringed on Mr. Gerber's rights to fly the U.S. flag. So along comes the legislature again.
Well, let me interrupt you because I think it's interesting that it kind of shows you that judges end up where they wanted to end up because there was no state action. Gerber sued the association.
Correct.
But the trial judge used what they called the company town cases back in the old days of the early industrial development of the country. Companies would own the towns and you had to buy your food there, you had to rent from them and all of that. And there was a line of cases from, I think, the 30s and 20s and 30s and 40s that said, we're going to consider these state actors. And the judge in this case considered the condo association to be the same as a company town. I think people that are really kind of constitutional purists scratch their head over that one. I frankly doubt that would have survived appeal up to the district court or, certainly, or the circuit court, excuse me, or the U.S. Supreme Court. But, it just kind of shows you that when a judge thinks this is an important right, I'm going to find a way to help the aggrieved party get there.
And to your point, the 11th Circuit, which is that guy's boss, is the same one that came out with Lauren versus Sasser years later. So you kind of know where they're going to be on this. And there's been other federal trial courts that have said, yeah, the judge there was a patriot more than a judge when applying the law. And, it's been pretty criticized, that case.
Yeah. Well, it's kind of moot on the flags because we have now an extensive statutory regulation. So why don't you go through that kind of briefly?
Yeah. So as we mentioned before with the peacefully assembled deal, the legislature says, look, we don't want constitutional arguments here. We're going to put into the Condo Act 718.113 and the HOA Act 720.304 the right to keep and display a United States flag. And on Armed Forces Day, Memorial Day, Independence Day, and Veterans Day, you can also fly the flags of the respective branch or the respective branches. So Army, Navy, Air Force, Marines, Coast Guard, and interestingly enough, in the Condo Act, Space Force, but not in the HOA Act. Space Force has not made 720 yet, but it is in 718. So you have the right there, no matter what the covenants say, to fly those flags on those days, and then on any day, the United States flag.
But that's the official flag of the United States, correct?
That's right. And the official flag of the United States is statutory by Congress. I mean, it is discussed in Title IV, Chapter 1 discusses what the official United States flag is to look like. It is the flag of the United States shall be 13 horizontal stripes alternating between red and white, and the union of the flag shall be 50 stars representing the 50 states, white in a blue field. So that is the official flag pursuant to federal statute.
So let's talk about non-official flags. There are flags that look like US flags, like the thin blue line flag, which is intended to support law enforcement, but it's not an official flag. It's got an off-color black stripe in it. Let's go beyond that. Pro-Trump, anti-Trump, pro-Biden, anti-Biden, Black Lives Matter, all lives matter, all of that. I mean, unless you're living under a rock, you know that we have become and continue to be a relatively polarized society on a lot of issues, unfortunately. And a lot of these things really evoke high emotions in people. So let's talk about your view of the ability of an association to regulate or prohibit flags other than the official US flag, which is covered by statute. So if I want to, hang my, you pick it, my Biden flag or my Trump flag or my anti-flags or my, rainbow flag or my Black Lives Matter flag or anything else, do I have an absolute constitutional right to do that?
So I'm going to answer your question first, and I'm going to back up. I think the answer is no. But the first thing you always have to do when you're discussing this with your boards, with your management, when you're the attorney, is go back to the rulemaking authority, right? Like, this is just enforcement 101. What rulemaking authority does the board have? What is in the document? So before we get to the constitutional stuff, which we're here for today to discuss, it's just important to remind everybody watching that while this is one facet of the considerations of when you adopt restrictions to go through and discuss with your attorney, there are others. There's the 101 of, do we have the authority to do that? So let's just assume, for the sake of argument.
And just to put a finer point on that, it matters. Is it condo? Is it HOA? Is it part of the lot/parcel? Is it common areas? Is it part of the unit or the common elements? And does the board have rulemaking authority over the units or parcels? Does the rule conflict with a right in the declaration, or that is inferable from the declaration? So that as you state, I mean, that's a seminar in and of itself, is the enaction of restrictions, what requires a declaration amendment, what the board can do. You mentioned at the beginning, category 1 and category 2 restrictions. Category 1 are basically those in the declaration or amendments. Category 2 are board rules. And there's a whole process there. So let's go back to the actual the actual law on this, because I mean, look, the law is what, in this context, what the courts say it is. And if the courts haven't really said what it is, then, there kind of ain't any. And I think we're in a little bit of that land here, but why don't you tell us what we have and, kind of how we maybe see this coming out, whether it's association is plaintiff versus defendant distinction, et cetera. So
yeah, I will always get back to that. I mean, two different issues. One is content restriction, right? Like, it's one thing to say you're allowed to have the flags that the statutes allowed you to have, and we are not going to allow any other flag. The University of Pittsburgh flag, University of Florida flag, the Biden, the Trump, the this, that, and the other. We're not allowing flags.
No, hold it. I went to Pitt undergrad and law school. I think that might be a religious flag, but let's take that example. So can an HOA, for example, say, hey, you want to put out your Michigan flag on game day? No problem. But when you put out your Trump or Biden flag, it's a problem. Is that okay?
Yeah, I say no. I say that's not okay. Right. Like, I think that's really problematic. I think that's content selection and content discrimination. And like, that's
right. So the point being, if if a non-US flag is not offensive in and of itself, then the board cannot regulate its content. So if the Go Wolverines flag is okay, the F Trump flag is okay too.
I mean, that's the argument for sure. That the board is deciding what is okay and what is not, versus just relying on the legislature to tell you what is okay and what is not. So
tell a little bit about the Murphy case, and we'll move on.
Right. So the Murphy case, again, out of the Tampa area, Middle District of Florida, federal case. It was a flag regulation case, and the owner there, again, remember, owner bringing this, said that the covenants contained in the Declaration of Condominium violated his First Amendment rights with respect to flags. And the court said, well, we're not even going to get to that question because the condominium association in this case is not a state actor. Go away.
That's the owner suing the association, just like the Quail Creek case from Naples and the federal, I believe, Ohio case of Lauren versus Sasser. In each case, the owner sued the association and the court said no state action. Yeah. We don't really have a case where the association has sued the unit owner and the state action issue, whether Shelley versus Kramer, the racial case, goes down the food chain anymore, right? I mean, so
that's exactly right. We don't know
of law,
read it more expansive or not. We know that they read it with equal protection. We know that for sure. We got that. Beyond that, it's a mixed bag of what could happen if the association brings the case.
All right. Well, then we're talking about politics now with the flags. We're coming up on the midterms. Let's talk about political signs, signs in the yard. I have my re-elect nobody signs all ready to put up. Can my HOA tell me that I can't do that? What's the deal on yard signs?
Yeah, so there's again no case from the association perspective on this other than the for sale signs. And there's some argument that could be made that the Supreme Court and the federal court systems view political speech different than they do commercial speech. So we don't.
I think that's clear. I don't even think it's an argument. Yeah. I think if you look by analogy to strict First Amendment cases, that commercial speech, like how a billboard advertising pest control can maybe block traffic, will be viewed, the municipality has more leeway than a political sign, right? Because commercial speech is not entitled to as much protection as political speech.
So even with that, though, you've got a 1984 Supreme Court case City of Los Angeles versus Taxpayers for Vincent. And in that case, the court held that posting of political signs on public property could be prohibited, and that wasn't an infringement on the First Amendment guarantees. However, fast forward to 2015.
Well, hold on. Let's just do that one slowly. That's in the United States Supreme Court case, 1984. And it said that the ordinance prohibiting posting on public property was not unconstitutional, correct?
That's correct. That's correct.
So talk about Reed versus Gilbert, Arizona.
Right. So then we're in 2015. And
another SCOTUS case,
another Supreme Court case. And this one had to do with a church and its pastor wanting to put signs up, temporary signs on private property, but it violated where the signs were located, the size of the signs, and how long they were going to stay out there, violated the city code, the town of Gilbert, Arizona, their sign code. And Justice Thomas, writing for the majority, stated that that code did violate the church and the pastor's free speech and was unconstitutional.
Okay, so
how do we
that case though involved a government actor, the town of Gilbert, Arizona, basically preventing speech through its ordinance. So, obviously the open question is whether a condo association or an HOA, which is not in general a state actor, would be subject to the same analysis. I would argue not. What about you?
Yeah, I would argue not as well. I think that if this ever gets challenged, it's going to go through the same analysis as the Lauren Sasser and the Quail Creek. And I think that they're going to say, look, yeah, it is political, but there are plenty of other places where this can be done, and this has private restrictions. And as long as we're not regulating content, as long as we're not saying you can do blue but not red or whatever, we're not allowing any of them, I think that they're going to probably have to.
So I think to summarize, pretty much all the cases in the association context where the owner has sued the association has said there's no state action. We don't really have a clear one where the state action issue has been litigated where the association sues the owner. Is that correct?
That's correct.
So what about this crazy case of Fox versus Hamptons at Metro West, which came out a few years ago? This seems to turn that whole thing on its ears. I really think the Fox case is interesting because it deals with the kind of in-your-face issues that our boards deal with. So why don't you tell us a little bit about the facts of that case and the holding?
Yeah, I can tell you that we got a lot of questions that lead right into the Metro West. We call it the Metro West case, but it's Fox versus Hamptons at Metro West Condominium Association. Mr. Fox was not a fan of the board or the management, and he let that be known very publicly through social media posts, continuously through online blogs, through contacting realtors. He did lots of, let's say, bad mouthing of the association. The association passed some rules to try to stop this. And ultimately, of course, Mr. Fox broke those rules. The association then sues Mr. Fox. And before it gets to the end of the trial court, they settle. And when they settle, they have a settlement agreement that says he's not going to do this going forward. And the court enters something called a consent final judgment saying, the parties have agreed to X, Y, and Z. The court retains jurisdiction to enforce the settlement agreement. And it ends. At least we thought it ended. Mr. Fox, of course, cannot keep his fingers from moving swiftly about all the bad things that the board and the management are doing. And the association goes back into court and seeks a motion for contempt of court for violation of the terms of the settlement agreement. And the trial court grants it, holds him in civil contempt of court, and that's where the appeal goes up. So on appeal,
Well, hold on though. I think it's important to emphasize one point is that the court's order in enforcing the settlement agreement precluded the owner from any further postings on social media negative to the board or management, correct?
That's right. That and no more blogs, no more new blogs. In fact, it went so far to say that if you are asked online about the association and your experiences with them, you have to pick up the phone and call the person. You are not allowed to write back. That's what the contempt order said. So that gets appealed. And the 5th District Court of Appeal says, whoa, whoa, whoa. You had me until prior restraint of speech. Prior restraint of speech is, look, you may get in trouble for things that you have said in the past, but this is saying you can't say those things or anything like them going forward. And that is.
Well, let's stop there because this is a very fundamental constitutional First Amendment issue. And you and I aren't experts on this, certainly, but the courts have said you can't yell fire in a crowded theater. Your free speech doesn't get you there. You can, you can't libel and slander people and use free speech. But generally, the government cannot gag you, including the courts. If you want to say what you want to say, you face the consequences. But we cannot, gags are not, generally not permissible in a free society of speech. If you do something wrong, you're going to pay the consequences. So prior restraints are generally invalid in First Amendment, types of issues. So basically, Jay, back to what you were saying, the appeals court said, yeah, this guy broke the settlement agreement and there's no doubt about it. But so let's talk about this but and the prior restraint aspect.
Yeah, so the but part was that the court said, look, they don't, by the way, they never used the word state actor. Not one time in this case does the court ever discuss state action. It just concludes, and I've thought through this, and I think the reason why that they did not discuss state actors is because it was the judge entering a contempt order. And I think that they're just saying, you are obviously the government, judge, and that's why we don't have to discuss state actor. I think they still should have discussed the state actor part of this, but they did not. And the court said you cannot tell Mr. Fox what he cannot say in the future. That violates his First Amendment guarantee to free speech.
So that's an interesting point, that because this was a contempt case, which carries the authority to imprison and not a run-of-the-mill civil dispute, although ultimately the judgments of injunction are enforced by contempt of court.
Sure.
Does that make a difference? Who knows? I mean, this case just pulled the Constitution out of the court's briefcase, for lack of a better word, and said the Constitution applies. There was no analysis of the state action issue. Maybe it wasn't raised by the attorneys who litigated it. Maybe they stipulated because it was a contempt case. So, again, we're kind of in the legal no man's land, but let's move this into another, kind of in your face, issue. Obviously, the advent of social media in the last couple of decades has transformed our lives. Even us oldsters are known to go on a few of them. I'm a little bit of a Facebooker. That's about it. I don't do any of the others, but
we'll get you on TikTok soon enough, Joe. I promise.
No, I don't think so. But yeah. So yeah, no comment. But a lot of things that we get or I get is there's just people that aren't happy campers in in their situations, including where they live and how it's run and how it's managed. And I see these things all the time. We see these Facebook groups. Let's say you're in the Blue Sky condominium. And it's, you see this blue sky owners, Facebook owners group, and all they do is bitch about the board and how incompetent they are and what ninnies the managers are and all of that. We get a lot of questions about that. One of the questions is, can they use the name Blue Sky in their Facebook group? And I think the case law is generally that they live in the Blue Sky condominium. So as long as there is not confusion that this is the association's webpage, it's going to be, problematic. Now, it could be different if you have registered trademarks or trade names with clubs and things, or, large master plan communities. It's not, there's no hard and fast law on it. But my sense is that as long as there's no confusion, the courts are going to be very unlikely to enjoin people from setting up their own, Facebook groups. But when they do that, it can negatively affect the operation of the association. I mean, I've seen them where, yeah, we think this manager, didn't have enough experience to work here, and she's overwhelmed and she's on her cell phone with her kids all the time, and, blah, 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 blah. And, these are public groups, and, how would you like to be that employee? That's not good management of employees to have the mob, able to do that kind of thing. I mean, who would want to work there? So, I have dealt with this. I don't think there's a magic bullet. I do have a number of clients that have adopted, conduct rules. We call them in the office the don't be a jerk rule.
Right.
The don't be a jerk rules, kind of depend on the issues in play, but a lot of them deal with a proper chain of command in expressing your concerns, opinions about the association's, employees. Frankly, I think board members are fair game, unless it's slanderous. I just don't think the courts are going to, afford that much protection. We all know, what a great job being on the board is anyway, and how much it pays. Well,
Yeah.
it's kind of like a public figure too.
Right.
But, with respect to employees, I think there's probably a little more leeway. But, let's say the board adopts, my don't be a jerk rule, and someone still continues to post on this private, we hate Blue Sky Facebook owners group, and we think the manager is incompetent, and we think the board's on the take, and we think that this is a terrible place to live and nobody should buy here. Jay, what in your background as a litigator, if a client came to you with those facts, would you tell them?
Well, I mean, the first thing I would think through is, are you a community where you have amenities that maybe we could restrict people from, because that's a non-judicial way of enforcement by and through 720.305 or 718.303. There are ways to kind of handle this in-house. And if you have the ability to do that, I would do that, because I
By a fine or a suspension because they broke the don't be a jerk rule.
That's right. That's exactly.
But then
right.
If we have to go to court to enforce the suspension or collect the fine, then we're back in the state action realm, right?
Yeah, potentially, yes. And but then, Metro West doesn't answer the question about punishing for breaking the rule. Metro West talks about the prior restraint going forward. So
would a court look at that don't be a jerk rule as a prior restraint when it says don't go on Facebook and bash our manager?
I mean, that's a good question. That's a good question. But the distinction, if I'm a litigator, I'm going to tell them I'd rather you not have to go to court on the don't be a jerk rule. But if we go to court, I think I could distinguish Metro West and say that we are punishing, however we're punishing, for enforcing the fine or the suspension, not on what could be said in the future, but what has already been said. Like, that's the best argument I think you're going to have.
Okay, so I was going to call this God, guns, and gossip. So we've talked about God and gossip. Let's talk about guns.
Okay.
Just so you folks are aware, I think one of the reasons Jay and I were asked to do today's presentation is that we have a particular academic interest in this subject. We co-published a scholarly article after the U.S. Supreme Heller case came out a few years ago. It was the first and really the first Second Amendment case, and kind of came on the heels of the Trayvon Martin shooting, and we thought it was an appropriate time to explore some of the technical legal issues, and we co-published a scholarly article that was published by the Florida Bar Journal, I don't know, was it 5-6 years ago on this, and if you're if you're really bored, read it, because it gets into, it's basically a lawyer's article on all the state action case law from all over the country on some of these. We were also invited to present this to the National College of Community Association Lawyers in Las Vegas. After we published it, Jay and I went out there, and I don't know what he and my two then 20-year-old kids did after I went to bed, but they told me don't ask, don't tell situation. But yeah, so we had some history in this, and of course the Bruin case that everybody's been talking about, which came out the day before after the abortion case that everyone's talking about, just came out like 30 days ago. Obviously this is a very concerning topic. The mass shootings in our country are just really, kind of mind-boggling. And we're not here to be pro or anti-gun control. That's really not the purpose of this. The point is that there can and has been gun violence in associations. The Trayvon Martin case was an HOA case. The HOA got sued in that case. There was another case where a disgruntled owner walked into the condo office and shot the manager and board president point blank and killed them both over, I believe it was a dispute about a driveway or something. So yeah. So one of the things that we do get occasionally asked is, can, and if so, should an association board attempt to address or restrict guns, firearm issues? So, let's take, to me, what is probably one of the more difficult questions to give a square answer to, but probably one that would concern me the most. Florida has, very liberal gun laws. You can get a concealed carry permit in Florida as long as you have not been convicted of crimes or on drugs or had, domestic violence and that kind of thing. There's a number of disqualifications, but in general, if you're not disqualified, you have an absolute legal right to get a right to carry a concealed handgun or pistol. So that being the case, if I have a concealed carry permit and I'm a known, hothead and someone that likes to criticize the board, can the board adopt a rule that says, no concealed weapons at association meetings? The courts have said you can restrict legal rights. You have a right to drink alcohol. One of the first condo cases said the board could prohibit alcohol on common elements, even though it's otherwise legal for adults to drink it. So, those are, kind of some of the issues, and we're going to end there. But let's begin with a very brief presentation, Jay, of the 2008 Heller case, which we wrote our article a few years after, and last month's Bruin case. So these are both Supreme Court of the United States cases. They are the two most significant, really the only cases on the reach of the Second Amendment under the Constitution. So Jay, tell us about them.
Yeah, so Heller, like you said, was the original one. And Heller, it's pretty basic in its holding. It's you have a right to have a gun in your home for self-defense. I mean, that's what it all boils down to. The
District of Columbia basically prohibited ownership of handguns.
That's right. And in that case, if I recall, Mr. Heller was a police officer too. And so they made sure they had the right plaintiff. And then there was another case called McDonald that's out of Chicago, but that basically made Heller apply to all the states. So that's what Heller says. You have a right to keep a gun in your home for self-defense. Bruin, it comes out of New York.
And this is the last month's case that's been in the news so much.
That's right. And what the state of New York had is to be able to get a concealed carry, you had to do something called provide proper cause. A proper cause has to exist. Now, it defines what proper cause is. Again, you're an off-duty police officer, you're a security officer, you're things like that. There's been some reason that you've been threatened and the courts have recognized that you've got a restraining order against somebody. There is some extra reason for you to be able to conceal carry in public.
But just because I want one for self-defense is not a legally justifiable reason under the New York law, correct?
That's exactly correct. And what Justice Alito said, writing for the court, is no, you cannot have a permitting scheme that requires something more than, that requires a proper cause element. Now, you can still have the disqualifying things that Joe talked about for Florida. The opinion does not go into the disqualifying things, but it says you can't have an extra reason other than just self-defense. And that's what New York was requiring.
Wow, you just summarized a 139-page decision in 3 sentences.
Yeah.
Kudos to you, Jay Roberts. Okay, so let's take that and let's talk about what we think absolutely cannot be banned in associations.
Right. So here I want to pause and say there's going to be 2 reasons for this. You remember at the beginning when we talked about the independent way that restrictions can be struck down, violation of public policy or abrogate fundamental constitutional right, or 2 of those. And what I'd like to say here is Chapter 790, which is the concealed carry and permitting statute, starts off by saying this chapter expresses the public policy of the state of Florida. They made sure to have that as part of the statute. So when you think about the reasons that Joe and I are saying here, it's not always because this could end up being a state action case or whatever. It could also tie into Chapter 790 Florida statutes, the gun statute.
And that goes back to the White Egret case from 1979, which was one of the first Florida Supreme Court cases on condo law. And it said the declaration is golden unless it abrogates a fundamental constitutional rights or basic public policy. So what the legislature has tried to do in Florida is to create gun ownership as a fundamental public policy, which makes it more problematic to regulate through even your declaration, right?
That's exactly right.
So what can't you do for sure?
You can't prohibit guns from being in the home, the parcel, of the unit. Can't do that. Can't prohibit the guns from being transported from the car, from wherever, to the units at all. There's a statute in 790 that talks about how employers.
790.251 sub 4, right?
That's right.
Go ahead.
that says that you cannot prohibit an employee or an invitee, and I'll let Joe explain how broad the invitee can be, from keeping a firearm locked inside of their car. So we can't keep the manager from not having a gun locked inside, locked away in the manager's car, sitting on the common elements. I would say that, you know, that's probably due to the Second Amendment issues to begin with, and due to 790 and what the concealed carry talks about, that you could expand that to the owner of the unit or the guest or the tenant of the unit as well, with respect to keeping those locked in the cars. So,
All right, so Jay, I have a lot of clients, probably some who are on this call, who say, "Counselor, don't tell me what I can't do. Tell me what I can do." So what can you do?
right. So discharging of the firearm for any reason other than self-defense. In fact, there's a statute on that, 790.15. If you are in a primarily residential area, it's a felony to discharge a weapon. So certainly that is something we can do.
Okay. Yeah. I think it's a misdemeanor, but yeah.
Is it a misdemeanor? I thought it was a third degree. Either way.
Well, I have every Florida law memorized, plus I have the really good memo you prepared right in front of me. It says misdemeanor. So, okay, so let's kind of end on what are the hard calls. Back to our, you know, can we ban lawful concealed carries in, you know, association meetings? And I'm going to address that because a program that Jay and I presented at in Las Vegas a few years ago had a panel of 4 or 5 other attorneys from all over the country as a separate program. And these are all attorneys who basically, you know, specialize in condo and HOA law. And I think the practical response that came out of that is, why is it really that important whether you can? Because the more important question is, should you? Let's say you could lawfully prohibit concealed carry at board and member meetings. Well, how are you going to enforce that? Are you going to pat people down? Are you going to, you know, wave metal wands at them? So, you know, there seems like a reasonably good chance that such a provision would not be enforced. It's not obvious. That's the whole purpose of concealed carry, is that, you know, the holding of the weapon is not obvious. So if you don't enforce it, and then, you know, tragedy does occur, I don't think there's any lawyer who would tell you you're in a worse position by having a rule you didn't enforce than not having a rule at all. I mean, murdering people is still illegal, even in Florida. And, you know, that's that. And to the extent, you know, associations want to consider, you know, trying to prevent that, which is an entirely, you know, desirable goal, you know, always look at, can you do it? If you can't do it or you won't do it, don't do it, because you put yourself in a worser legal position, to use the technical term. So in 59 minutes, hopefully we didn't put you to sleep or bore you to death, or if you were drinking something stiffer than lemonade, you didn't feel the need for a second or a third. So we do have your questions, and as said, we do use those in formulating future content. We hope you enjoyed this program. Jay and I kind of get a kick out of this stuff. It's a little bit out of the box of what we deal with, and maybe we were those law school nerds who sat in the front row and raised our hand all the time. I wasn't. I don't think Jay was either. But one question we do get, we did get a number of, is this available for board members who couldn't make it? And, you know, it kind of always reminds me of when I used to go trick-or-treating. I'd say, my brother is sick, can I get his candy? And everybody would give me some. So then I'd say, my 2 brothers are sick, can I get theirs too? But yes, we do post these on our firm website. So if you navigate our website, there's a link to them. And we also post them on YouTube, which I think is the platform our website takes us to, but you can also search them through that. And those of you that participated will receive an actual link. It takes us a couple days to get it, downloaded or whatever. And for those that, so you could forward that link if you'd like. And also, if you don't have the link anymore, or somebody just wants to know, they can visit our website or search YouTube, and they would be able to access this program along with all of our other programs. We had record attendance a couple of weeks ago, over 2,000 observers or participants on the program we gave on the new condo structural safety laws. So while this one is a lot more interesting and cool, that one
we were also better looking than those guys.
Yeah, right.
Except for Donna.
Yes.
Donna's better looking than us, but the others are not.
Yeah, well, okay. Well, you can't have it all. So we are going to end this. I don't know, Laura Benson, are you here to close things out? Jay and I are done.
Mm-hmm. Yes. So yes, thank you everybody for attending. And as Joe mentioned, in 1 to 2 days, you'll receive that that email with the link to the webinar replay. All right. Well, have a great day.
Okay, so we are going to go ahead and just continue this connection.
Yes, you can hop off whenever you're ready.
Okay, over and out. Have a good day, everybody.
Bye.
Bye-bye.
Okay, bye.